the court basically concludes that Revenue Canada was fine with asking for exchange of information. They've asked the taxpayers twice. The taxpayers have lied about this, according to Revenue Canada, or might have lied about this twice, and therefore they exchange information, and the court is totally fine with this. And I think the takeaway here for taxpayers are, if you're lucky if you asked once. If you asked twice and you still deny something, you cannot complain if the tax authorities are then going to verify that information with other sources such as the foreign government. And then we come to the full and frank disclosure to the Swiss authorities. And here the big part was, this thing about what about 14 and 15? That was not audited. Okay. And so at the hearing, the appellant made much of the fact that the Levett Baazov RFIs seek information regarding 2011 to 15 taxation years, while Messrs. Levett and Baazov were audited for 2010/11. There was a difference there between the two up to 2013. They claim that the CRA simply cannot have exhausted all reasonable domestic avenues with respect to 2014 and 15, right? Because they haven't even started an audit that. At first glance, the appellants have a point. However, there is more to it than in the record. The auditor explained that she included these two taxation years in the Levett Baazov RFIs because the TMF decision against the insider trading decision made reference to the fact that the account of Optivilla holding held with Bank UBP had been closed in 2016, and that account's credit balance had been transferred to another Swiss financial institution in an account whose holder could not be identified. And apparently there was some link here between these two gentlemen and that company and the accounts, and then she was going to open 2014 and 15 in a next step as part of the audit. The auditor also explained that she considered seeking information from Messrs. Levett and Baazov, but anticipated that no other results would have been expected than what was obtained from them when they were questioned about 2010 to 13. So, if you lied to me about 2010 to 13 already, why would I expect you to tell the truth about 2014-15 is what the auditor claimed. And the court says, I would add that Swiss authorities were aware that the actual audits contemplated by Levett Baazov were covered the tax years only for 2010 to 13, and that the CRA intended to extend these orders to 2014-15. And the Swiss decision literally says so in so many words. This is what transpires from a decision of the Federal Court of Switzerland issued October 2019 that we'll look at later. With respect to the 2014 and 15 years in particular, the Swiss court found that the CRA was entitled to assume that the appellants would provide the same denials regarding any investments or income abroad. So even the Swiss court said, you know what, if this is what these guys said about 2010 to 13, they'll probably say the same with regard to 2014 and 15, and therefore you can come and ask us the question. Now, the next point that the taxpayer complained of is they said that there was a disclosure of confidential taxpayer information to the Swiss authorities, right? And this was very formalistic. The appellants submit that the CRA exceeded what was allowed to communicate to the Swiss authorities. They say that the information the CRA is allowed to communicate in support of an RFI made under the tax convention can only be that listed of Article 2B of the interpretive protocol. So you can only give the information from step 1 to 5, and you can't give anything more. And the court says, I think quite rightly, I see no merit into that argument. I share the respondent's view, and the respondent is the CRA, that paragraph 2B of the interpretive protocol establishes a threshold, not an upper limit, right? This is the minimum information we need before we can give you any information, because we need to know what you're talking about, right? It sets out that what the requesting state shall provide. I see nothing in the wording of that provision which would prohibit the CRA from sharing background facts with the Swiss authorities, right? So this argument of the taxpayer simply doesn't fly. As observed by the federal court, the information that forms part of an RFI is not left in the open, as paragraph 2 of Article 25 of the Tax Convention holds that the Swiss authorities are hold the Swiss authorities to secrecy with regard to that information. So I mean, of course, the exchange of information is covered by confidentiality. Yeah, and then therefore the court throws out this argument. And then with regard to the solicitor-client privilege issue, this stems from an information collected in the course of the audits of Kathy Benishman and Natalie Benishman. So this is the Benishman audits. It was a whole different audit. These audits were conducted from 8 to 13 tax years in connection with the sale of shares of a Quebec registered corporation to a Spanish corporation. So again, the sale of shares by the women. And then the court says, be that as it may, I need not to decide that particular issue since the appellants face, in my view, an insurmountable obstacle here. Indeed, as found by the federal court, the issue is irrelevant in the circumstances of this case because that information gathered by an auditor other than this case's auditor was in the context of that audit and was therefore not considered for the purposes of these RFIs. So you can't say that you can they use that information because the auditor, I think, said that she was not even aware of this information at the time of submitting the RFIs, right? Only came to the forefront later. And then the Canadian court ends with a message: for all these reasons, I find that the federal court, in reviewing the request for information's validity, chose the correct standard for review and applied it properly. I would therefore dismiss the appeal with cost, and the information between Switzerland and Canada can be exchanged. So let us now look at what the federal court in Switzerland said, and I'm just summarizing various observations here. The federal court decided, as you saw in the beginning, a year or two before the Canadian court, and the issue at the federal court was whether the taxpayer managed to stop the tax authorities from exchanging information with the Canadian Revenue as the Canadian Revenue has asked, and they failed. But the court made a couple of interesting observations, and I apologize here terribly for the layout of these slides. The original text is in German. The text is translated with Google Translate. It's not always very accurate, and the layout is terrible as the font sizes jump from small to large and backwards. But anyway, the content is here, and 2.2 said, according to the case law of the Federal Supreme Court in Switzerland, a suspension of the procedure must be justified by sufficient reasons, because if there are no such reasons, a person with the requirement to accelerate is to be assumed. So what the court here says is, the administrative law says if there is an exchange of information request, generally the information should be provided as quickly as possible rather than as slow. And the taxpayers have asked, please suspend the exchange of information. We've got a court case going on in Canada about this, so let them decide first before you exchange the information, right? And then the court says, when deciding whether the procedure should be suspended, the authority has considerable discretion. And what the court says here is that means that the court itself needs to hold back on rejecting the authority's opinion. And 234, finally, the present proceedings should not be suspended because the Federal Administrative Court has no serious doubts about the exhaustion of the usual domestic resources by the Canadian authorities. So the court says here, like the Canadian Court of Appeal says, you don't have to try everything, right? Pursuant to Article 25, Paragraph 1, Sentence 1 of the treaty between Switzerland and Canada, the competent authorities of the contracting states exchange information that is likely to be relevant for the implementation of this agreement or for the application or enforcement of domestic law with regard to taxes covered by the agreement. What is understood by reasonable means is not further defined in the treaty or the interpretation protocol. It follows that the exhaustion of all possible means is not required, right? Rather, a means can no longer be described as reasonable, and even less as reasonable or raisonnable if it would cause the requesting state a disproportionate amount of effort compared to the request to the administrative assistance, or if the chances of success can be assessed as very low. The requesting state is thus given a certain amount of freedom. And what the court here refers to is, like, again, the taxpayers have been asked twice whether they have any assets outside of Canada. They denied it twice. So, how much more do you need to ask them before you can go for an exchange of information, just like the Canadian court says? And the Swiss court goes on to say, the requesting information does not mean that the request for administrative assistance may not yet be made, especially if the person is obliged under the applicable law to submit all essential documents. So the court now goes to explain when you can ask for exchange of information and what you can do under exchange of information, right? And it says, nor can a state be prevented from remaining in contact with the taxpayer or from questioning them, even if an administrative assistance has already been sought. So you can go on with business as usual and ask for an exchange of information at the same time. And then the court finally says, according to the so-called principle of trust, and this is an interesting point that it raises, under international law, there is no reason not to accept presentations of facts and declarations from other states, except in the case of obvious abuse of rights or legitimate questions in connection with the protection of Swiss or international policy. And so what the court says here, the taxpayers say the Canadian revenue authorities are lying, but on a state-to-state basis, the state basically has the obligation to believe what the other state says, unless it is manifestly wrong, right? And talking about wrong here, the Google translation actually dropped the not, while the German text originally very clearly says that there's no reason not to accept the presentations and declarations from other states. So we'll have to really be careful with Google Translate. The court goes on and says on the 4.1, it should be noted that the Canadian Revenue Authority has given assurances that it has exhausted all national resources to the extent practicable. In principle, this assurance is to be used as basis. Again, state to state, we need to believe what they say. To the extent that the complainants assert that the CRA was able to apply coercive measures directly to them in order to obtain the documents, it must be said that the Federal Administrative Court of Switzerland had already come to the conclusion in previous proceedings that the application of such measures cannot be requested. So again, when is it reasonable to ask for exchange of information, and when have you exhausted all local resources? You don't have to go to the extent where you coerce taxpayers into giving you information. You can stop before that and ask for an exchange of information. Interesting point of view that the Swiss court brings up here. It then goes on to say the CRA also assumes that complaints 1 to 4, so this was against the two gentlemen and their wives, have accounts that they did not declare in their tax returns. These accounts, so the suspicion are that these are Swiss banks and are partly operated by non-Canadian companies. Or they're held by non-Canadian companies. Since the CRA would not have been able to question these companies directly because they're not Canadian, and they also have no direct access to Swiss banks because they are Swiss banks, not Canadian banks, they had to use administrative assistance. So the Swiss court defends the Canadian decision here. And it goes on to say it should also be pointed out that the tax audit in Canada does not have to be completed before a request of administrative assistance is to be made to Switzerland. On the contrary, it can be assumed that the examination cannot meaningfully be completed without information from Switzerland. So again, a very pragmatic approach by the Swiss court. And then finally, it says in 4.15, again, the taxpayers' denial coming back to haunt them with respect to 2014 and 15. The CRA has indicated that it will conduct a tax audit for those years as well. This must be accepted in accordance with the principle of trust that we talked about before. Since the CRA assumed that the complaints had not specified all income amounts or income for the years 2011 to 13 or 10 to 13, depending on about which gentleman you're talking about, they were allowed to make the same assumption for the following years. In other words, if you lied about 10 to 13, you probably will lie about 14 to 15. Also, with regard to the years 2014 and 15, the Swiss court says it can be assumed that the CRA has exhausted the resources as far as this makes sense. dismissed. And then the court concludes the motion to stay the administrative assistance process until the Federal Court of Canada has ruled is dismissed. In other words, Switzerland can exchange information, and the complaint from the taxpayers is submitted. This is dismissed. This is a rather long case this week, so I will keep it short. I look forward to seeing you next time, and I hope you enjoy this case. We don't very often get cases like this. Forget about two countries deciding on the same case when it deals with exchange of information. Bye for now.